Ladies and gentlemen, it is now an official countdown to a unanimous Supreme Court ruling overturning the Colorado ban, the absurd, unconstitutional ban of President Trump, who has never been convicted of a rebellion, nor did he engage in a rebellion. You'd have to be a complete imbecile to think that Trump tried to overthrow the country with unarmed supporters he never met, while the Federal Bureau of Investigation found no evidence of any concerted effort to try to overthrow anything, of any effort at all. Hit subscribe right now. It's the official countdown on this channel. It will be an historic rebuke of a really stupid, highly apoplectic effort, undemocratic and despotic, to try to prevent Trump and disenfranchise tens of millions, 7 to 80 million Americans from choosing their president. In a couple of seconds, you'll hear from Justice Clarence Thomas, who, along with John Robertson Kavanaugh and Amy Coney Barrett and Justice Alito and Justice Gorsuch, along with the liberal Supreme Court justices, I think will go ahead and give a unanimous reversal of a very, very unconstitutional decision. Hit subscribe to my super chat. Thank you so very, very much. And let's get started, ladies and gentlemen. First of all, you can read The Hill, Daily Beast. If you could believe this, MSNBC even has everyone is gearing up for the most monumental rebuke and refutation of the Colorado ban, which is the essence of the D.C. case against Trump. Why a 9-0 SCOTUS decision would be helpful. This is MSNBC, so they all know what's taking place, and they're trying to run ahead of the obvious embarrassment. They will all be mortified when it happens, and it will happen. Hit subscribe to this channel, ladies and gentlemen. The ban will be overturned, and the only issue now will it be 7-2, 8-1, or 9-0? I think it'll be 9-0. Check out also the segment prior to this one regarding the $10 billion Trump just made through the Truth Social merger that was allowed by the SEC. Let's go ahead and let's listen to the Honorable Justice Clarence Thomas.
Do you have contemporaneous examples? And by contemporaneous, I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples, because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting
So what's the
federal
purpose
officer.
of what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War, and there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then.
The reason there are no examples of states utilizing the 14th Amendment to disqualify candidates is because they would not have been given that power under the 14th Amendment. It was not meant to allow southern states to disqualify any candidate. It was meant to remove power and influence from southern states. Okay, furthermore, you would have to be convicted or in Congress be found guilty of a rebellion. And so there are other statutes and there are other laws already in the books on a federal level to disqualify somebody who indeed committed a rebellion. So you wouldn't, and the thing is, the reason there was there haven't been any examples is because there wasn't the modern day Democratic Party, or there wasn't a political party like today's Democratic Party trying desperately to ban a candidate they know they'd lose to. So Democrats know they'll lose to Trump. That's why they're trying to indict him a million times under 91 criminal charges and get him off the ballot with the Supreme Court. It has nothing to do with the rule of law. The political aspect of all of this is completely lost upon those that say, well, the rule of law, the rule of law. Paul Bartlett, Nicholas Orm, thank you. To my viewers around the world, in Australia, everywhere, thank you so very much. Paul Bartlett, I cannot thank you enough. You too, Nicholas Orm, I cannot thank you. In Australia, thank you, everybody. So, to my super chat, feel free to, if you want to support the channel, make any analysis or comments. But it's going to be a unanimous Supreme Court ruling, 9-0. If I'm wrong, it'll still be 7-2. Okay? And here you have the nation. The Supreme Court is not going to save us from Donald Trump. Like, oh yes, the record low poverty that we had, the record highs in household median income, the Doha Agreement that brought Americans home from America's longest never-ending counterinsurgency conflict that Clinton and Kerry and Biden and Bush, Cheney, and Rumsfeld got us into. The first president to step foot in North Korea. The only a president who gave more funding to historically black colleges and universities than any president ever is Trump. Okay. Again, we had low inflation, low interest rates, with low unemployment, and a record low in poverty. Yet the nation says the Supreme Court is not going to save us. Save us from what? A great economy? Yeah, the Supreme Court's not going to save us from the apoplectic meltdown of wonderful, morally superior Democrats who can't simply accept defeat like in 2016 and then accuse Trump of not accepting defeat. It's this meltdown, this never-ending, it's like this entitlement. The Democrats feel they should be in power forever. It's like, well, we tried Biden, and now we're going back to Trump. Okay, we tried Biden, we're going back to Trump. What does that tell you? What does that tell you? Let's go ahead, and so that was amazing. You will hear also the liberal Supreme Court Justice Kagan right before Amy Coney Barrett. So this is really interesting.
To make it put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected, I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence.
Why would he? He hasn't been convicted of a crime. The whole point is that the Supreme Court, and this is why media is trying to get ahead of the most embarrassing and monumental and catastrophic defeat for Democrats. The reason that the Colorado lawyer is saying, well, states get to choose their what candidates on the ballot, and if we found that Trump committed a rebellion and he tried to overthrow the country and he tried to sell the planet to Martians and he tried to take a spaceship and steal the Constitution and fly to Saturn and sell that Constitution, the U.S. Constitution, to space extraterrestrials on Saturn. We found that to be true, and so we've never had this before, where a president would go and take a spaceship to Saturn and sell the Constitution. We just never had it before. So obviously the Supreme Court should go ahead and decide. He wasn't convicted of anything. He wasn't convicted of anything. That's the whole point. Dr. Debo Cherry, thank you. That's the whole point. Paul Bartlett and Nicholas, thank you. Ozzy, hello. That's the whole point. He wasn't convicted of anything. You can't just say that we think Trump tried to sell the planet to Martians, so therefore, because we think that's the case, we are going to then kick him off the ballot. It don't work that way. And that's exactly the rebuke when Democrats accuse Trump of committing a rebellion, and it's a 9-0 Supreme Court decision. Okay? The Supreme Court will be telling the world Trump did not commit a rebellion, and if you believe that he tried to, you have to convict him first, which you won't be able to because he didn't. So yet again, another fantasy, another lie, the biggest and greatest lie of all, will be completely dismantled. Okay, a Supreme Court ruling is imminent, ladies and gentlemen. Absolutely imminent. And it's going to vindicate former President Trump. Let's continue here. I want to go ahead and this is Jonathan Turley. This is not Jonathan Turley. Jonathan Turley will be up in a second. This is a wonderful, wonderful journalist at Fox News.
Jonathan Turley, law professor at GW University and Fox News contributor. This was Elena Kagan asking about who should decide this for the whole nation. Can we watch that?
Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law. And
what's your read of the question and the answer?
Well, I think that the advocates for disqualification probably expected a cold reception, but this was perfectly glacial. I mean, the problem for Jason Murray is that his toughest questions came from the left of the court. Many people have been saying how the conservatives are going to sandbag this entire appeal and how they have to look deeply within themselves. Many of the toughest questions were coming from Justice Jackson and Justice Kagan. And Justice Jackson notably kept on raising this first question, which is perhaps the presidency is just not covered by this provision. And she has always taken a particular interest in the 14th Amendment and had said, it's plausible that he was not. And some of the other justices raised the fact that the 14th Amendment was designed to take power away from the states. And yet, as Chief Justice Roberts said, you are curiously finding that there's a provision here that radically expands that power. And that seems to go against the entire tenor and purpose of the 14th Amendment. This was really a tough going. Jason Murray did as good a job as he could do, but I imagine he wanted to do everything short of pulling the fire alarm at one point, because he was just getting hit from all sides in this argument.
I mean, at one point I was watching this and I said it felt more like a congressional hearing than a discussion at the U.S. Supreme Court. I mean, it was pretty interesting, and no politics involved, just lots of big personalities with big questions. Amy Coney Barrett then kind of backed up with her own questioning, that whole point about, can one state really decide this issue for the whole nation? That seemed to be a hinge point.
It did, and they really did play out the implications of this. And this is where I think Murray had a very hard time. These were questions that were hitting him below the waterline. And he didn't have a really good answer for it. Every one of them, including some of the liberal justices, kept on coming back and saying, how are we going to handle this? You can have different states applying different standards. A number of the justices said, what's even our review? Do we have to accept what Colorado did? Because even their own justices said that there was no due process here. Some of them raised the fact that they relied on this professor who said that he could divine meaning in coded terms from Trump's speech. And the justices, a couple of justices referenced that and said, is this going to be the record we deal with? What are we supposed to deal with? How are we supposed to review that going forward if we've got a dozen states doing this?
So Democrats always find coded meaning, a subtext, within Trump's words. Nothing within Democrats' words, whether it's Chuck Schumer literally going after Kavanaugh and then Kavanaugh having his life almost taken from him by very likely a person who was influenced by left-leaning dialogue and rhetoric. Okay, so Schumer targeted one Supreme Court justice and then apologized for it, and no uproar or indignation from Democrats. Then you have other Democrats in Congress giving specific statements, almost a roadmap to how to create political chaos and violence. And of course, literally asking people, telling people to get in the faces of supporters of Trump. And so you have a huge problem, ladies and gentlemen, when Democrats focus only on Trump and his words, ignoring the fact that the man said a peaceful, go there peacefully. Did not say try to overthrow the government. Said go there peacefully. Let's go ahead and listen to Alina Habba, who was fantastic. She was absolutely fantastic. And we will get to her in a second.
Meet now.
Here.
So this relates, ladies and gentlemen, to my segment prior to this one, my live stream prior to this one. She's also, I believe, going to talk about the Colorado decision, but she's focusing primarily in this and another discussion She's focusing on the absurd ruling that not only will be overturned, but is overshadowed now by the $10 billion merger that Trump just won through the SEC approval. Che, if you don't know what I'm talking about, check out the segment prior to this one. It's doing very well. Hit subscribe also if you're new to this channel.
I'm not here to hear what he has to say. That was what rang true, loud, and could not have been more honest, coming from the judge who has already predetermined that my client committed fraud before we even walked into this courtroom. I'm not here to hear what he has to say. Then why exactly am I being paid as an attorney, and why exactly are taxpayer dollars being used in this courtroom? The answer is very clear. Because Miss James wants to stand right here like she did this morning and call my client a liar, call the company fraudulent, and make a name for herself. She said this morning that the numbers don't lie and they won't lie in this case. Well, Miss James, I have a message for you. The numbers didn't lie when you ran for governor, and that's why you dropped out. And the numbers don't lie when President Trump runs for office in 2024. And those numbers are loud and clear. This country is falling apart. And if we don't stop corruption in courtrooms where attorneys are gagged, where attorneys are not allowed to say what they need to say to protect their clients' interests, it doesn't matter what your politics are. Everyone has a right in this country to get up and put a defense. I don't care who you are. You have a right to hire a lawyer who can put objections on the record. You have a right to hire a lawyer who can stand up and say something when they see something wrong. But I was told to sit down today. I was yelled at, and I've had a judge who is unhinged slamming a table. Let me be very clear. I don't tolerate that in my life. I'm not going to tolerate it here. And you know what? You shouldn't either. Because not every American citizen gets a camera and a microphone. And what I'm seeing is such a demise of American judicial system and democracy. Miss James came out this morning and said that she knew Mr. Trump, and she always calls him Mr. Trump because it kills her that he was the president. But the 45th president of this country, one of the best presidents we've had, has built a great company. It's worth a ton more than that statement of financial condition. And she doesn't know how to get out of it because her politics won't allow her. She calls him a bully. She says he's going to bring out racial slurs. He's going to say things today and taunt her. Well, Miss James, you taunted him. Before you came into office, before you saw one record, one statement of financial condition, you taunted him. You said his administration was too male and too pale. Those are her words. She said that she and Michael Cohen were going to be his biggest nightmare. Well, I have some news for you, Miss James. Michael Cohen folded, lied, and crumbled. Your star witness, along with all the DAs and corrupt AGs, need to be paying attention to what happens when you let us take the stand. When you let my client speak the truth, and the judge can tell me to sit down, and he can try and shorten my client's testimony, but it is loud and clear. They've got nothing. They've got nothing but their politics. She's got nothing but her Soros backing, which we discovered recently. And I am sick and tired of seeing it. Pay attention, America. Pay attention. Because when you're in court one of these days, and you don't have a lawyer that has a microphone, and you don't have a lawyer that can go on TV, and you've got judges gagging them, what are you going to do? We need to fix this country. And we need to stop what is happening in this courtroom.
So they are using state prosecutors. Democrats have been using state prosecutors against Trump. And media doesn't bat an eye. They don't care. Media doesn't care because media is an extension of the Democratic Party. That's why you have late night comedians. That's why you have all of Hollywood. Thank goodness, not really any more social media algorithms, because Elon Musk buying Twitter was huge, turning it into X, huge. But you have, ladies and gentlemen, a concerted effort, an overt and concerted effort to stop Trump, to bankrupt him. And in New York, these statutes have never been utilized. In Colorado, the statute, the 14th Amendment was never utilized. Then they say, well, Trump is a unique case. Yeah, he's unique only because he's up in the polls and Democrats will lose to him in November. It's not only a countdown, ladies and gentlemen, on this channel for the Supreme Court decision. Nicholas! Thank you so very much, Nicholas. My goodness, thank you, Nicholas. Christina, hello. Nicholas, thank you. It's not only a countdown for the Supreme Court ruling, it's a countdown to November, ladies and gentlemen. Trump will regain the Oval Office. The man is going to win again. Does everybody understand, ladies and gentlemen, he's going to win despite the absolutely hysterical effort the past 7 years, the past 8 years since he won, of Democrats who disown friends and family, ruin Thanksgiving and dinners and get-togethers with their completely irrational diatribe and ranting about how terrible Trump is and how immoral he is. We're going back to Trump again. Thank God. He's going to win again after we tried 4 years of horrendous presidency with Biden. But let's listen to Alina Habba again. So because what she says pertaining to the New York lawsuit, and Nicholas, thank you again. What she says pertaining to the New York lawsuit directly has direct impact, or directly correlates to the Colorado ruling being overturned.
Good evening. So let's talk about one thing that the press hasn't reported. We just listened to testimony from a man who has such distinct recognitions as an accounting expert that even Letitia James's team and the OAG's team used him themselves as an accounting expert. Professor Bartov was the New York Attorney General's expert in the Exxon case. Let's start there. But today, when he was on the other side, they spent the entire day objecting because he was giving testimony that didn't suit their claims. His testimony included that there was absolutely, and I quote, no fraud, that the statement of financial condition for President Trump was understated, that there was no evidence of concealment, and that, in fact, President Trump's statements of financial condition had something that most other statements of financial condition don't have. 18 pages of descriptions and details about his properties, about his trophy assets, things that most people don't need to do and wouldn't do. The reason? Because he had nothing to hide and he didn't conceal anything. This is not a publicly traded company. This is a private company. And the Attorney General is now sticking her nose into private companies. This is a very scary moment for our country. We have to have boundaries. We have to have laws. They were objecting every 5 minutes, and I really give credit today to the press that was in there. I did look at some of the feed, and it was accurate. There was absolutely no fraud. The statements were undervalued, and President Trump and the Trump Organization provided Deutsche Bank with everything they needed. Last week, we heard banks make clear that they thought they were a trophy client. They were the big whale that they wanted to get, and they valued their relationship. They said that holds true today. I don't know why we're here. I've said it before, and I say it again. Again, this case has absolutely no merit, and you don't have to believe me. A man that gives the Nobel executive committee recommendations on accounting and who should be recognized in accounting, that man that just sat in there for the entire day made it very clear and had words with the AG and said, this, you should be ashamed of yourself. And I say it too. You should be ashamed of yourself. Thank you.
What will the former president be prepared to say at his own behalf?
I'm not going to speak about privileged information. At this time, the president is looking forward to taking the stand and once again making clear that he cooperated, he performed on his loans, they were paid ahead of schedule in some instances, always on time, and he was never in default. But somehow Miss James needs to fulfill her political promise, so we're here, and he'll be addressing all of that on Monday. Don't forget, though, he's going on Monday with the judge's gag order still in place, so he can't speak about certain things. He has to be so careful. That is so unconstitutional, in my opinion. We have First Amendment rights, we have rights as attorneys, Sixth Amendment rights, and those are all being violated. And he still wants to take the stand, even though my advice is, at this point, you should never take the stand with a gag order. But he is so firmly against what is happening in this court and so firmly for the old America that we know, not this America, that he will take that stand on Monday.
What can we expect on Monday?
The same as we've heard. The same as we've heard from experts. He will clarify it. He will open himself up to whatever they want because he's not afraid. People that are afraid cower. President Trump doesn't cower. We'll be back on Monday with that, and tomorrow we'll hear more testimony from this incredibly intelligent man.
What was your client's reaction to the testimony today?
I think he made it clear. It's more frustration that we have wasted time, that they are doing election interference. This is a tactic that we've seen time and time again. This is not the first or last of it, and we're going to have to deal with it in all the other trials. But I really hope this is a lesson to those other AGs and DAs out there trying to make a name for themselves off of President Trump's back. If you're going to do it with garbage claims, it's going to come out because there are experts willing to put their heads out, willing to put their necks out, and willing to say that this is garbage. And we heard that today, the entire day, and we will hear that well into tomorrow. I don't speak about politics. I'm a lawyer.
But no, with all the cases that are stacked against him,
Yeah.
does he still feel confident about Monday, the outcome of this case and everything that's...
The outcome of this case was determined before we walked into court. Let's be clear. We're not walking into this court every day expecting that this judge is going to let us off.
Alina Habba is absolutely brilliant. She's absolutely fantastic. And you get these, like, you can look on YouTube, you get these channels trying to make a living off of disparaging Miss Habba. And the problem is that she's doing a fantastic job. The channels going after Trump's attorney or Trump's lawyer ignore the blatant fact that New York, for example, is politically persecuting Trump. It's a go and look for the wonderful, morally superior, highly educated liberal Democrats who don't understand. Look up Tammany Hall. What does Tammany Hall mean? Okay, it's a New York political machine that's, what, over 150 years old. So New York has been a political machine for a long time. A Democratic Party political machine, like Chicago, like other major cities in this country. So you have to look and ask, well, why isn't, like, Democrats look and they say, you look and they say, well, they're going after Trump because he committed fraud. Like, no, he didn't. And Kevin O'Leary, who's not political, Kevin O'Leary from Shark Tank, he is basically called the state a loser and said that now businesses are leaving. Businesses and developers will start leaving New York if this isn't overturned on appeal. So they get these short-term victories, and then a couple of days later, Trump gets a $10 billion merger. A $10 billion merger. So it's like, you can't, I mean, and check out the segment, the live stream prior to this one. You can't get Trump on his finances or pretty much anything. Democrats are just, the entire world knows that Democrats are going after Trump, trying to kick him off the ballot, trying to bankrupt him, and just trying to utilize, like despots and authoritarians and totalitarians, the state, federal government, media, all against them. Trump's a really bad despot when he has no control over the media narrative or state prosecutors or federal prosecutors, like Democrats, who have virtually complete control over all of these things and utilizing all of them against Trump, their direct political rival. All of their talking points that they used over the years, Trump is going after his direct political rival. That's what they're doing to Trump. But it's like the arrogance and hubris, won't allow them to actually see what they're doing. All right, let's go ahead.
Was a
Let's wrap this up. You will hear eventually John Roberts.
there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th. Since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group.
He wasn't convicted of that, nor was he indicted of that. He was not convicted nor indicted of committing a rebellion. So, that being said, ladies and gentlemen, be here tomorrow at around 3 p.m. Eastern, about 4 p.m. Eastern, everybody. I will see you tomorrow to my super chat. Paul Bartlett, Nicholas Orm, thank you so much. Let me fix this. All right, how's the audio now? How is the audio now? How's the audio, everybody? Better? Still not good. Okay, so ladies and gentlemen, be here. Tough it out. Hello. Be here tomorrow. Florida Man Bear. Hello. Be here tomorrow at around 4 p.m. Eastern, everyone. Hit subscribe to this channel. Thank you so very much. Check out the segment prior to this one. It's a pretty good one. And I'll see you tomorrow, everybody. Thanks for your support. Countdown has begun, everybody. The countdown has begun.